Now, assuming you've at least got an idea of where these people are, you need to figure out how much they owe you. And first step is you start out with the amount on your judgment. Since you have a judgment, I'm assuming you know it. You're then going to need to add any collection costs that you've incurred up until that point, add interest, and that is the total amount that you're going to seek to collect. Now, the interest is going to accrue from the date of judgment at 10% simple interest, which will make it relatively easy to calculate. So, give you an example. Let's say that you start out, your total interest is going to be the judgment times 0.1 divided by 365 multiplied by the number of days since the judgment. Putting that into English, you start out with your judgment, you figure out what 10% of it is, because that's your annual interest. You divide it by 365, that gives you daily interest, and multiply it by the number of days to get the total. So for example, let's say that you got a judgment of $18,500. It was entered on June 15th, 2007, and because I made this presentation back on February 27th, let's say today's date is February 27th, 2013. Well, any number of date counters are online, including one at timeanddate.com, and you can figure out that the duration between those two dates is 2,059 days, which would then give you 18,500 times 0.1 divided by 365 times 2,059, or $10,436.03. That's the hard way to do it. There's also, now keep in mind that if they've paid anything off at any time, you're going to be doing an interest calculation for each segment, taking in mind any principal reduction that has taken place. So this is the hard way to do it. It's always worth knowing the hard way, and if for some reason you're the type of person who really, really enjoys doing your taxes and things like that, you might have some fun doing it. Or you can just do the easy way. There's a really nice judgment calculator at the San Diego Court website, and it allows you to enter in the date of your judgment, the amount of the judgment, any payments and the dates that the payments are made, and it gives you a nice breakdown of what is currently owed. It really is pretty user-friendly. Since these tools have a tendency to come and go, it's always good to know the manual way, but there will usually be something like this online, and this is my current favorite one. Once you know the total amount of interest and the costs that you've incurred, you would go ahead and update this with the court, and you would do this by filling out a memorandum of costs after judgment and serving that and filing it with the court. This is a standard judicial counsel form. It's form MC012, and it's really pretty straightforward. Since you all have judgments, I'm going to assume that you're familiar with the layout of a court document, so you know how to fill out this top caption. Attorney or party without attorney, well, that's you. Name of the court and the address, the name of the plaintiff, the name of the defendant, and I'll give you 3 guesses what goes in case number, and the first 2 don't count. Yes?
Can you only use it in the county court, or can you use it in federal court also?
No, this is only used inside of the state courts. No, federal courts use their own, have their own collection techniques. They're very similar in many ways, but they are their own sets of forms and procedures. Once you complete this form, this caption, there's a section in item number 1 that allows you to indicate what previous expenses that you've incurred, what costs in collecting the judgment. If this is your first time through trying to collect, you're not going to have anything there. But if you've previously tried to do this, you're going to have costs for previous attempts to issue writs of execution, record abstracts of judgment, things like that. And you would just list the dates and the total amount that you paid and total it up. And if this total amount is going to be less than $100, you can actually just include it when you try to collect it right away. Otherwise, you would have to wait until the other side misses its opportunity to dispute this before you could add it in. But 100 is going to be permissible right away. Item number 2 is any previously allowed costs. So if you filed one of these before, it's whatever the costs were from the previous one or ones totaled up, and you get a total. Acknowledgement of credit, how much has this person paid you? And you would put whatever they have previously paid. And then the declaration of accrued interest. This is the amount that you previously calculated as far as how much interest is added on. And then finally, you identify who you are, whether you're the judgment creditor, the agent for the judgment creditor, or the attorney for the judgment creditor, date, print, sign, and you get to then serve this on the attorney for the other side or the self-represented party on the other side by mail, and you submit it and file it with the court. The other side, if they wish to challenge this, they can file a motion to tax costs, but generally, I'm assuming you're putting down all legitimate and allowed debts. It's not really going to do a whole lot there. And the costs will tend to be fairly small. It's that interest that really grows. So once you've updated the costs with the court, you need to get an idea of what you're going to collect against. Find the assets of the other side. Well, first thing you want to look for is recorded property. Do they own a house? Do they own rental property? Do they own investment property? Whatever. And the way that you can easily find this is by going through the clerk recorder for whatever county that they might have property. This is going to be on a county by county search. So unfortunately, the tools that I'm going to show you for Sacramento County, you need to figure out what the equivalent is in whatever county you might be looking for. Although there are a few databases, for example, by Westlaw and Lexis, that are called asset locators, where they, will have the data for many different offices indexed to make it a little bit easier. But if you're just doing this on your own, this is going to be something you're going to do county for county. In Sacramento, the recorder's office is just a block away at 600 8th Street, and you can also, if you go on to the county recorder's office, they have an online index of recorded documents, which is, makes it very easy to see if there's anything worth going downtown to look at. So this system that they call eRosie, it allows you to do a name search, and then you can specify either a range of dates, or you can even go search by decade. And once you search back a few decades, you can see any documents that are recorded in that person's name. And this is going to pull up deeds, transfer deeds, utility liens. It will also pull up other abstracts of judgment that have been recorded from other people who they owe judgments to. So you'll be able to see the type of the document, you'll be able to see the names of the parties to the document and what type of document is. And what you're typically looking at is going to be typically grant deeds, where they are the people who it's being granted to, the grantee. And if you see property that's recorded in their name, that's going to be, it'll give you the actual, the book and page number that you're going to be requesting. And it's worth going down and actually looking at the record to see what it is. If you see absolutely nothing, well, then you know that they're not going to have anything most likely in this county. And you may check some other counties. Now, one last thing about the clerk recorder's office that I wanted to mention is that the documents themselves that they've got links to the assessor, and they've got their own, an access to the assessor's office through their office, but they're not linked with their data. So you would probably have to do a two-part step to actually find the address of the property, because you'll be able to find the document, the deed, the legal description of the property through the recorder's office, and then by cross-referencing through the assessor's office data, find the actual physical address. This, by the way, also crosses over into the locating the debtor, from the previous step. Now, the other thing that you might consider is if you know any of the other creditors, any of the other creditors this debtor has, have you gotten any information from them? One technique that's possible to do is actually do a business record subpoena for information from their other creditors involving, for example, their credit applications, their last payments, things like that. Because if you, do that, you're able to obtain, for example, copies of checks that they've sent to their other creditors. So you can figure out where they're banking. If their credit application, they're going to list a number of different bank accounts potentially, and other information that would be useful to figure out what they might have. One disadvantage of this technique is that it puts the person on notice that you're looking their information up. Because one of the things you do when you do a business record subpoena is you send out a notice to creditor, or I mean a notice to a notice to the to the consumer of that you're seeking personal information regarding them, and this will let them know of the subpoena. And they're going to they could potentially file a motion to quash the subpoena since they're a party to the case. They might also just know that you're looking for their information, and what they do with that information is up to them as far as, now that they know that you're trying to collect against them. But I wouldn't be surprised to see bank accounts shifted around, things like that, making it a little more difficult to collect. But it's one way that you can do things. The other thing that's useful is sometimes if you can find on the credit application where they work, although people will oftentimes shift things around and out of bank accounts quickly, very few people change jobs unless they absolutely have to. So you may be able to find out their employer this way as well. Now, one pitfall, and this is a pet peeve, because I tend to see things oftentimes from the debtor side through the library as opposed to the creditor side. One pet peeve that I have is there are a few attorneys out there that do these business record subpoenas, and they botch them. When you designate the deposition officer on these subpoenas, it cannot be a party to the case, or an attorney, or the attorney's staff. And I will oftentimes see them put themselves as the deposition officer, and this opens them up to motions to quash. I've seen several of them. But if the other creditor is local, you can still easily check box C, to inspect things personally and go out to their location and inspect the documents. Or hire a legal photocopying service to act as your deposition officer.